For the most part, the answer is no, but there are some exceptions. One has to do with if the debtor has been in state court and lost and appeals the decision of that state court to the higher state court, so the appellate court, then when the debtor files a bankruptcy petition, the automatic stay stays that appeal. Interestingly enough, if the debtor is suing in the California Superior Court and files the bankruptcy, that filing doesn't stay any lawsuits that the debtor is prosecuting against somebody else. But if there's an appeal, then it does stay the appeal. And in that situation, if the debtor wants to continue with the appeal, the debtor will file that motion for relief from the automatic stay and ask the judge to lift the stay so that the debtor can continue with the appeal. It does get to be a little bit tricky depending on the chapter. If it's a Chapter 7 and the appeal has the potential for paying the debtor a lot of money that can't be exempted using an appropriate exemption table, then the right to that appeal may belong to the bankruptcy estate, and it's the Chapter 7 trustee who has the standing to prosecute the appeal. So in a situation like that, it might really not be some great benefit to the debtor to have the stay lifted to continue with the appeal. But if it's in a Chapter 13 or a Chapter 11, especially a Chapter 11 where there typically isn't a chapter trustee, then not only is it in the debtor's best interest to get the stay lifted to proceed, but the debtor may actually have an affirmative duty to get the stay lifted to continue with the appeal, because the debtor serves as a quasi-trustee called the debtor in possession. This is in a Chapter 11 to gather assets for the benefit of creditors. So yes, there can be a benefit to the debtor. There can also be a benefit to the debtor if there is a question of the dispersion of property, marital property during a dissolution. In fact, I had a case a few years back where a debtor came to me. He had been in a Chapter 13 bankruptcy case for a couple of years, and I didn't file the original case, someone else did. And his divorce proceedings had been stayed. The actual divorce itself proceeded, but the allocation of marital assets had been stayed. And he really wanted to get those assets divided so that he could take his half and use it for whatever purpose he had in mind. And so in a situation like that, we filed a motion for relief from stay to have the judge lift the stay so that he could return to the divorce court and pick up where he and his ex-spouse had conducted their divorce so that they could get the final division of assets. So yes, there are times where a motion for relief from stay is filed by the debtor and can be very much in the debtor's best interest.